Welcome once again to our commerce classroom. In this session, we will discuss about free consent. Free consent. All of you know that all agreements are contracts if they are made by the free consent of the parties. All agreements are contracts if they are made by free consent of the parties. Two or more parties are said to consent when they agree upon the same thing in the same sense. According to section 13 of Indian Contract Act, two or more persons are said to consent when they agree upon the same thing in the same sense. Consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, or mistake. I repeat, consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, or mistake. Firstly, we discuss about coercion. Coercion. Section 15 of the Contract Act defines coercion as follows. Coercion is the committing or threatening to commit any act forbidden by the Indian Penal Code or unlawful detaining or threatening to detain any property to the prejudice of any person whatever with the intention of causing any person to enter into an agreement. I repeat, coercion is committing or threatening to commit any act forbidden by Indian Penal Code or unlawful detaining or threatening to detain any property to the prejudice of any person whatever with the intention of causing any person to enter into an agreement. In law, prejudice means harm or injury from some action. In law, prejudice means harm or injury from some action. The definition of coercion can be analyzed as follows. Our first point, when the consent of the person is obtained by committing or threatening to commit any act which is forbidden by the Indian Penal Code, the consent is said to be obtained by coercion. Our first point is this: the consent of any person is obtained by committing or threatening to commit any act which is forbidden by the Indian Penal Code. That consent is said to be obtained by coercion. Example: X threatens to kill Y if he doesn't lend him rupees 5 lakh. Y lends the amount. Here, the threat amounts to coercion. The second part of definition of coercion is this: if a person unlawfully detains the property or threatening to detain the property of another person and forces him to enter into a contract, the consent is said to be induced by coercion. I repeat, if a person unlawfully detains the property or threatening to detain the property of another and forces him to enter into a contract, the consent is said to be induced by coercion. For example, an agent refused to hand over the account books of a business to a new agent unless the principal released him from all liabilities. The release deed was given under coercion and was voidable at the option of the principal. A threat to commit suicide amounts to coercion. You people have to note this point. A threat to commit suicide amounts to coercion. Then, when the consent to an agreement is caused by coercion, that agreement is voidable at the option of the party whose consent was so obtained. I repeat, when the consent to an agreement is caused by coercion, that agreement is voidable at the option of the party whose consent was so obtained. Then we discuss about undue influence. Undue influence. Section 16, subsection 1 of the Act, a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. I repeat, Section 16, Subsection 1 of Indian Contract Act. A contract is said to be induced by undue influence. Two conditions. First condition, where the relation subsisting between the parties are such that one of the parties is in a position to dominate the will of the another. One of the parties is in a position to dominate the will of the another. And second condition, he uses that position to obtain an unfair advantage over the other. Section 16, Subsection 2. A person is deemed to be in a position to dominate the will of the other in the following cases. Section 16, Subsection 2. A person is deemed to be in a position to dominate the will of the another in the following cases. First case, where he holds a real or apparent authority over the other. I repeat, where he holds a real or apparent authority over the other. Example, master and servant, parent and child, income tax officer and assessee. In all these cases, one person holds a real or apparent authority over the other. Second case, where he stands in a fiduciary relation to other. Fiduciary relation here means a relation of mutual trust and confidence. Fiduciary relation here means a relation of mutual trust and confidence. Example, guardian and watch, solicitor and client, doctor and patient, guru and disciple, trustees and beneficiaries. In all these cases, we can see fiduciary relation to other. Third case, where he contracts with a person whose mental capacity is temporarily or permanently affected by reason of age, illness, mental or bodily distress. Example, old illiterate persons. I repeat, where he contracts with a person whose mental capacity is temporarily or permanently affected by reason of age, illness, mental or bodily distress. Then we discuss about relationship which arise, presumption of undue influence. Relationship which arise, presumption of undue influence. Parent and child, trustee and beneficiary, religious guru and disciple, guardian and ward, solicitor and client, doctor and patient, fiancé and fiancée. In all these cases, there is a presumption of undue influence, but no presumption of undue influence in the following cases. No presumption of undue influence in the following cases: husband and wife, landlord and tenant, creditor and debtor. I repeat, no presumption of undue influence in the following cases: husband and wife, landlord and tenant, creditor and debtor. We have to note this point. Where a person who is in a position to dominate the will of another makes a contract and the transaction appears to be unconscionable, the burden of proving that the contract has not been caused by undue influence shall lie on the person who is in a position to dominate the will of the another. I repeat, where a person who is in a position to dominate the will of another makes a contract and the transaction appears to be unconscionable, the burden of proving that the contract has not been induced by undue influence shall lie on the person who is in a position to dominate the will of the another. Then we discuss about distinction between coercion and undue influence. Distinction between coercion and undue influence. First distinction is this: in coercion, consent is obtained by giving a threat of an offense or committing an offense. In coercion, consent is obtained by giving a threat of an offense or committing an offense, while in undue influence, consent is obtained by dominating the will. In undue influence, consent is obtained by dominating the will of other. Second difference is this: coercion involves physical force. Coercion involves physical force. Undue influence involves moral pressure. Undue influence involves moral pressure. Third difference: coercion has to be proved by the aggrieved party alleging it in. Coercion has to be proved by the aggrieved party alleging it in. It is not presumed by the law. It is not presumed by the law. There is a presumption of undue influence in the case of certain relationship. There is a presumption of undue influence in the case of certain relationship. Fourth distinction between coercion and undue influence is this. In coercion, the aggrieved party who is rescinding the contract has to return the benefit received to the other party. I repeat, in coercion, the aggrieved party who is rescinding the contract has to return the benefit received to the other party, while in misrepresentation, the aggrieved party may or may not be required to return the benefit in all or in part as per court's direction. In misrepresentation, the aggrieved party may or may not required to return the benefit in all or in part as per the court's direction. Fifth distinction between coercion and undue influence is this. Coercion entails criminal liability. Coercion entails criminal liability. Misrepresentation doesn't involve any criminal liability. Misrepresentation doesn't involve any criminal liability. These are the distinctions between coercion and undue influence. Then we discuss about misrepresentation. Misrepresentation. The term misrepresentation means a false representation of fact made innocently or non-disclosure of a material fact without any intention to deceive the other party. I repeat, the term misrepresentation means a false representation of fact made innocently or non-disclosure of a material fact without any intention to deceive the other party. A false representation made by a person may be either innocent or unintentional, that is, without any intention of deceiving the other party. We call it as misrepresentation. I repeat, a false representation made by a person may be innocent or unintentional without any intention of deceiving the other party. In that case, we call it as misrepresentation. And then secondly, intentional or willful or deliberate, that is, with the intention of deceiving the other party. Intentional or willful or deliberate, that is, with the intention of deceiving the other party. In this case, we call it as fraud. Under section 18, there is misrepresentation in the following three cases. Under section 18, there is misrepresentation in the following three cases. First case, unwarranted statements. Unwarranted statements. If a person makes a statement of fact which is not warranted by his information, he is said to make a misrepresentation. If a person makes a statement of fact which is not warranted by his information, he is said to make a misrepresentation. Second case, breach of duty. Breach of duty. When a person commits a breach of duty without any intention to deceive the other party and thereby gains something while the other party loses, it will be termed as misrepresentation. I repeat, when a person commits a breach of duty without any intention to deceive the other party and thereby gains something while the other party loses, it will be termed as misrepresentation. Then third case, inducing mistake about subject matter. Inducing mistake about subject matter. If a party to an agreement induces the other party, although innocently, to commit a mistake as to the nature or quality of subject matter of the agreement, he becomes guilty of misrepresentation. I repeat, if a party to an agreement induces the other party, although innocently, to commit a mistake as to the nature or quality of the subject matter of the agreement, he becomes guilty of misrepresentation. Then we discuss about essentials of misrepresentation. Essentials of misrepresentation. Our first point, there must be a representation or breach of duty. There must be a representation or breach of duty. Second point, the representation must be of facts material to the contract. The representation must be of facts material to the contract. Third point, the representation must be untrue. The representation must be untrue. Fourth point, the representation must be made with a view to inducing the other party to enter into the contract. Fourth point, the representation must be made with a view to inducing the other party to enter into the contract. Fifth point, the other party must have acted on faith of the representation. Fifth point, the other party must have acted on the faith of the misrepresentation. Sixth essential of misrepresentation is this. The person making the representation honestly believes it to be true. The person making the representation must honestly believe it to be true. Then we discuss effects of misrepresentation. Effects of misrepresentation. The effect of misrepresentation is that it makes a contract voidable at the option of the party whose consent is so obtained. The effect of misrepresentation is that it makes a contract voidable at the option of the party whose consent is so obtained, and such party may put an end to the contract if he so chooses. But there are certain exceptions. First exception is this: where the other party had the means of discovering the truth with ordinary diligence. The party cannot claim of misrepresentation if he had the means of discovering the truth with ordinary diligence. Second exception is this: where the misrepresentation doesn't induce the other party to enter into contract, the contract is not voidable. I repeat, where the misrepresentation doesn't induce the other party to enter into the contract is not voidable. If the consent is given independently in spite of misrepresentation, the contract is not voidable. If the consent is given independently in spite of misrepresentation, the contract is not voidable. These are the exceptions to the general rule. Then we discuss about fraud. Fraud. The term fraud includes all acts committed by a person with an intention to deceive the other person. I repeat, the term fraud includes all acts committed by a person with the intention to deceive the other person. According to section 17, fraud means and includes any of the following acts committed by a party to a contract or with his connivance or by his agent with the intent to deceive other party thereto or his agent or to induce him to enter into the contract. I repeat, according to section 17, fraud means and includes any of the following acts committed by a party to the contract or with his connivance or by his agent with intent to deceive the other party thereto or his agent or to induce him to enter into the contract. First point, the representation that a fact is true when it is not true by one who doesn't believe it to be true. The representation that a fact is true when it is not true by one who doesn't believe it to be true. Second point, the active concealment of a fact by one having knowledge or view of the fact. The active concealment of a fact by one having knowledge or belief of the fact. Third point, a promise made without any intention of performing it. A promise made without any intention of performing it. Fourth point, any other act fitted to deceive. Any other act fitted to deceive. Fifth point, any such act or omission as the law specifically declares to be fraudulent. Any such act or omission as law specifically declares it to be fraudulent. Then we discuss, can silence be fraud? Can silence be fraud? According to the explanation to the section 17, mere silence as to facts likely to affect the willingness of a person to enter into a contract is not fraud. This explanation has certain exceptions. First point, mere silence amounts to fraud when the person keeping silent is under a duty to speak. I repeat, mere silence amounts to fraud when the person keeping silent is under duty to speak. Silence is fraudulent in contracts of utmost good faith. Silence is fraudulent in contracts of utmost good faith, that is, contracts of abrime fide. The following contracts come under within the class of contracts of utmost good faith. First one, fiduciary relationship. Fiduciary relationship. Example, principal and agent, solicitor and client, guardian and ward, trustee and beneficiary. Second, contract of insurance. Contracts of insurance. Then another contract of marriage engagement, contract of marriage engagement. Then contract of family settlement, share allotment contracts. All these contracts come under fiduciary relationship. Second exception, silence is fraudulent where the circumstances are such that silence in itself is equivalent to speech. I repeat, silence is fraudulent where the circumstances are such that silence in itself is equivalent to speech. For example, B says to A, If you do not deny it, I shall assume that the horse is sound. A says nothing. Here, A's silence is equivalent to speech. If the horse is unsound, A's silence is fraudulent. Then we discuss about effect of fraud. Effect of fraud. First effect, right to resign the contract. Right to resign the contract. The party whose consent was caused by fraud can resign or cancel the contract. The party whose consent was caused by fraud can resign or cancel the contract. Second effect, right to insist upon performance. Right to insist upon performance. The party whose consent was caused by fraud may, if he thinks fit, insist that the contract shall be performed and that he shall be put in a position in which he would have been if the representation made had been true. I repeat, the party whose consent was caused by fraud may, if he thinks fit, insist that the contract shall be performed and he shall be put in a position in which he would have been if the representation had been true. Third effect, right to claim damages. Right to claim damages. The party whose consent was caused by fraud can claim damage if he suffers some loss. I repeat, the party whose consent was caused by fraud can claim damages if he suffers some loss. Then we discuss distinction between misrepresentation and fraud. Distinction between misrepresentation and fraud. First distinction is this. Misrepresentation is innocent wrong without any intention to deceive. First difference, misrepresentation is innocent wrong without any intention to deceive. Fraud implies an intention to deceive, it is deliberate or willful. Fraud implies an intention to deceive, it is deliberate or willful. Second difference, misrepresentation gives only the right to avoid the contract and there can be no suit for damages. Misrepresentation gives only the right to avoid the contract and there can be no suit for damages. Fraud is a civil wrong which entails a party to claim damages in addition to the right of resigning the contract. Fraud is a civil wrong which entails a party to claim damages in addition to the right of resigning the contract. Third distinction between misrepresentation and fraud is this. In the case of misrepresentation, the fact that the aggrieved party had the means to discover the truth with the ordinary diligence, it will prevent the party from avoiding the contract. I repeat, in the case of misrepresentation, the fact that the aggrieved party had the means to discover the truth with ordinary diligence will prevent the party from avoiding the contract. But in the case of fraud, accepting fraud by silence, the contract is voidable even though the party defrauded had the means of discovering the truth with the ordinary diligence. I repeat, but in the case of fraud, accepting fraud by silence, the contract is voidable even though the party defrauded had the means of discovering the truth with the ordinary diligence. These are the distinctions between misrepresentation and fraud. Then we discuss about mistake. Mistake may be defined as an erroneous belief concerning something. Mistake may be defined as an erroneous belief concerning something. It may be of two types. Mistakes may be of two types. Mistake of law, mistake of fact. Mistake of law, mistake of fact. Firstly, we discuss about mistake of law. Mistake of law may be of two types. Mistake of law of the country and second, mistake of foreign law. Mistake of law of the country, mistake of foreign law. Firstly, we discuss about mistake of law of the country. Mistake of law of the country. It doesn't render the agreement void. It doesn't render the agreement void. It is based on the well-established rule of law, namely, all of you know it, ignorance of law is no excuse. Ignorance of law is no excuse. Section 21 lays down that a contract is not voidable because it was caused by a mistake as to any law in force in India. And secondly, mistake of foreign law. Mistake of foreign law. The mistake of foreign law has the same effect as a mistake of fact. I repeat, the mistake of a foreign law has the same effect as a mistake of fact. Therefore, it renders the agreement void. It renders the agreement void. Section 21 lays down that a mistake as to law not in force in India has the same effect as a mistake of fact. Section 21 lays down that A mistake as to a law not in force in India has the same effect as a mistake of fact. A second mistake, mistake of fact. Mistake of fact. Mistake of fact may be of two types. Mistake of fact may be of two types. Bilateral mistake and unilateral mistake. Bilateral mistake and unilateral mistake. Firstly, we discuss about bilateral mistake. Bilateral mistake, where both the parties to an agreement are under a mistake as to a matter of fact essential to the agreement is void. The agreement shall be void if the following conditions are satisfied. First condition, both the parties must be under a mistake. Both the parties must be under a mistake. This means that mistake must be mutual or common. Second point, mistake must relate to an essential fact. Mistake must relate to an essential fact. It is necessary that the mistake must relate to a matter of fact which is essential to the agreement. I repeat, it is necessary that the mistake must relate to a matter of fact which is essential to the agreement. Then we discuss the various cases that fall under the bilateral mistake are, first one, mistake as to subject matter. Mistake as to subject matter. When both the parties to an agreement is working under a mistake relating to the subject matter, the agreement is void. I repeat, when both the parties to an agreement is working under a mistake relating to the subject matter, the agreement is void. Mistake as to the subject matter covers the following cases. First one, mistake as to the existence of subject matter. Second, mistake as to the identity of the subject matter. And third, mistake as to quality of the subject matter. Fourth, mistake as to quantity of the subject matter. Fifth, mistake as to title to the subject matter. And lastly, mistake as to the price of the subject matter. Then our second case, mistake as to the possibility of performance. Mistake as to the possibility of performance, where the parties to an agreement believe that the agreement is capable of performance. Where the parties to an agreement believe that the agreement is capable of performance, while in fact it is not so. While in fact it is not so. In that case, the agreement is treated as void. In that case, the agreement is treated as void. The impossibility may either be physical or legal. The impossibility may either be physical impossibility or legal impossibility. I think the topic free consent explained here is clear for all of you. We will meet again. Till then, goodbye.